Sorry this video is a little bit late after my week of gremlins last week. I've been fixing things on my computer and hopefully that will fix things up. TASAC haven't gotten back to me about what happened during the lecture last week, so fingers crossed it'll all be okay. But anyway, on to the weekly topic, weekly video for week 7. And this week it's all about precedents. So last week we looked at rules, and I've already, I think, fairly exhaustively talked about the difference between rules and precedents and the way in which law, or at least our idea of law, is constructed from an interplay between these two concepts. So this week we're really looking at precedents, and we're really looking at the common law in that regards. Now, again, remember there are some times when the parts of legislation acts as a precedent, where there are example sections where they will say, you know, it is illegal to keep a dangerous dog. Dangerous dogs include the following breeds, and that sort of sets up the same sort of thing in a head that the common law does. But of course, even that list of examples is something the common law can then come in and amend and modify later on. So in terms of legal skills, specifically legal research skills, one of the key skills that you have as a lawyer is being able to track changes in the law, and by doing that to be able to anticipate developments as they occur. You might not necessarily be able to predict an exact development, but you usually can say it's probably going to be this or that. And that familiarity comes through immersing yourself in the law, understanding the law. And back in the old days, they made you read 200 cases a term. You didn't even have a textbook, you just read 200 cases. I'm talking about when I was learning. And the idea was that somehow you would just figure it out as you go, and you do figure out something as you go, mostly that you don't like reading 200 cases a go. But it also means that there is value in being selective and actually reading some cases that are the right sorts of cases. Definitely wouldn't recommend reading every case on a reading list, but it's definitely worthwhile looking at some of the big ones, particularly ones where there are lots of judges involved, so a high court case, and where there's a contentious issue that's decided. Because what you need to do is to work away from the simplistic idea of the law, which is you've got a question and the law provides an answer to it, to the more complicated idea that law is something that's constantly changing, constantly in flux. And what a lawyer does is to sort of be able to understand where the status quo sits in the law and understanding where it's going. So I know in the first year of your studies we simplified things a lot for you, and we said the case of Jones against Smith means this. But as you go on, you'll find that any case that's worth reading or understanding is never ever that simple. If it was that simple, then the judges would just say this is the answer. But the way the law is structured is all about ambiguity. Generally, the judges will provide a direct answer for the particular case before them, but they never ever provide a direct answer for future cases, because you can always distinguish a case. You can always turn around and say that one was a blue car, this is a red car. Obviously, it's a completely different case. Or hopefully you'll have something more substantial in which to distinguish a case, but you usually can. There's usually a way in which you can distinguish, but then you have to be able to say, is this case sufficiently different that you can ask the judges to make a different decision? So this skill in terms of tracking and predicting is not exactly straightforward with rules and legislation, but it's more straightforward because you're in a position where you can say, well, what's the political water around this at the moment? Is Parliament going to act? Is it worth their while? Is it worth their expense? Is there a lot of pressure from the electorate to change the legislation? Are they debating it in Parliament? Are they saying, we need to change the law to do this? You know, we need to have more taxes for poor people and fewer taxes for corporations. In which case you can see, you know, those changes coming in the law as it goes. But you don't have that discourse around the courts. The judges don't go out in any way, shape or form and say, you know what, I'm really hoping someone brings, you know, a new equity case before us because I'm really itching to, you know, look at the rules around equitable estoppel, because I think it's time for that to change. You don't have any of that sort of discourse. You might have a bit of gossip in academic circles, in journals, where they say, oh, it's about time that if an appropriate case appears before the court, they may change these. But you don't have the sort of political discourse you have around rules. And there are several other reasons that make predicting what the common law is going to do quite difficult. So the first of this is that the law only ever engages with legal change when a case is brought before it. The courts can't go out there and make a declaration. They have to wait for an appropriate case to appear. And that may take forever, particularly if the people whose decision it is to appeal the decision decide that they don't want to run the risk of the law changing. So, for instance, there's been some lower court decisions in Australia in the last decade or so around privacy, where a lot of big media corporations lost in the state courts on the recognition of a common law right to privacy. Now, there is at the High Court level, there's no recognition of a right to privacy. So ordinarily you'd think, well, if the High Court gets its hands on an appeal, the time was right for them to reconsider a common law right to privacy. However, because the media corporations are the ones who have all lost, it's in their court to take an appeal, and they're not going to take an appeal because they don't want to run the danger and they want to run the risk of the High Court changing and making a definite proclamation on the matter. So the politics around the when a case comes before the court are much more complicated than in Parliament. The next complexity when it comes to understanding the way in which common law works is that the state of the common law is collaborative. It's the work of many different hands across time and across different jurisdictions. It's not something that you can easily say, the court intends this. Like if I were to ask you for a judgment on something, do you think this looks all right? It would be all your work and saying, yeah, it's right, or yeah, it needs fixing. Does the leg on this table look straight or not? But common law draws on the work of a lot of different people over time, and it expressly does this through the doctrine of precedent, and that makes it very, very difficult to be able to talk in terms of intention or design or the way in which the court thinks. We do that all the time. We use those sort of metaphors, and we say, oh well, the court in this case clearly intended this, and the court clearly meant that this was going to happen. But that's actually not true. That there is no one intention of the court because of this. It's the same way that when people talk about what the founding fathers meant, there is no single intention there either. Law also is complicated, or common law is complicated to use because it uses analogies. And there isn't a direct line of authority, quite usually, where a court says, we have to do this because the precedent says this other court made this decision. I mean, lower courts have to do that. The High Court, of course, is free to do whatever it wants. So what it uses is analogies, and it looks for patterns. And one of the key skills in understanding common law is really pattern recognition and understanding how those patterns may figure in the future. And again, this is one of the things that you get out of a law degree, is not necessarily that you remember a lot of the content that you study, but you understand the form of reasoning and you understand the way of thinking that enables you to start looking for those patterns. And when you come to a fresh area of law that you haven't studied or that has changed since you studied, you can turn around and go, this is probably the way the court's going to go because of these reasons. And because they use this analogous language, law often uses metaphor and symbolism. And this is often where concepts like justice and equality come in. They're through the use of these ideas of fairness or justice, but they're never directly reflected. You notice that they're always filtered through precedents, which is the most appropriate precedent. So it's not the circumstance you get in some other jurisdictions, non-common law jurisdictions, where the judge sits down and says, okay, as a judge, I think this is what the correct answer is. It's always filtered through these metaphors and in precedent, even if in reality what the judge actually does is make the decision and then go to precedent to back up what they intuitively decide is the right answer. So this creates a slightly different understanding of how the law works as a layperson may have, or someone who's just beginning their studies may have. We tend to think about law in a fairly monolithic way. And again, we often use terms like, well, the law says this, the law says you can't do that, or the law has these rules. And we think of the law as being something that's solid, whereas the actual structure of the law is more like a net. It's a network of different things that has plenty of holes in between, and that's part of the way in which it works, is that the holes actually allow us the freedom to go about our business, and the strands of the net actually are there to provide that sort of certainty and control and regulation in society. But it is a different way of thinking, and I think if you think of law as a monolith, as this big solid thing, start thinking about it as a network. It catches the fish you want to catch, and hopefully it lets the other fish and other things in the water through, and doesn't create a problem in that way. And even within common law, there's a lot of idiosyncratic metaphors that are used and have been used throughout history to understand what common law is and what the system of precedent is, because it's something that has evolved as it's been used, and there has never been a meeting where everyone sat down and said, this common law thing, how does it all work? So Matthew Hale, who's one of the key theorists of common law, referred to the fact that, or the scientific fact from his era, which was the sort of 18th century, I think, that the human body will change all its cells and all its parts over 7 years, but you'll still seem to be the same person, even though in reality they are all different cells to the person that you met 7 years ago. They've all been replaced. Now, I'm not sure how good the science of that is, but as a metaphor, you understand how the common law is constantly shifting, constantly changing, but it still seems to be the same law because, it has that continuity. Jeremy Bentham, the political philosopher, didn't have such a great opinion of common law. He called it an ill-shapen heap of odds and ends. He also called it nonsense upon stilts. And that was because Bentham was in favour of legislation and codification, and he was the designer of what became the Queensland Criminal Code. So he said, if you want to know what's a crime, you shouldn't have to go to all the law books and search all the law books. It should be something you can look up in one place. So he was quite critical of the common law, and he thought that Hale's insistence that it had this coherence and this consistency wasn't true, that it was quite incoherent. Other metaphors have been used over the years. The idea of a river. This came into the merger of the courts of common law and the common law and the courts of equity. And they talked about there being two rivers flowing together. But that's another way of thinking about the law as this constant travelling stream. Other people have talked about it as a garden, which does raise the question of who is the gardener. And it has a sort of a strange, sort of slightly religious Garden of Eden kind of vibe to it, that one. But again, this is this idea that there's all these things in the garden, and then the lawyers or maybe the judges go about sort of trimming the edges and taking out some of the dead plants and putting in new plants. I'm running through a lot of these things that you're going to talk about in jurisprudence as well, but just to give you the idea that what we do when we research precedents is not as straightforward as what we do when we look at rules and legislation. Other people have talked about evolutionary principles and look at the patterns that emerge out of the whole. So when you look at things that in nature work on emergent behaviour, like a coral reef, all the little corals are all doing their own thing, but in the big picture, when you step back from it, you actually see a coral reef developing in the same way that all the lawyers are actually doing their own thing along the way, and you actually see the common law emerge from that. And if you are at all interested in scientific theory, complexity theory has a very interesting take on what would be the foundation of common law development. You've probably seen the Mandelbrot fractals, that are those wonderful weird sort of patterns that when you look into them closer and closer, you see the same patterns emerging the closer you look. Well, complexity theory says that complex rule systems are built out of simple chunks of rules, and if you build things out of those simple rules, you get patterns emerging overall, and that sounds to me very much like the way in which common law develops. Anyway, we've been talking about gardens and rivers and Mandelbrots and fractals and whatever else. How does this actually help us as a research student? Well, the first thing it does is it tells you not to look for certainty and not to expect consistency every time. And there's another video I've done on what I've called the phantom zone, and what you do when you look for the phantom zone in the common law. But I think that's an important mental step to take, is to not ever expect the common law to be utterly coherent and utterly certain, that it's always something that's conditional. It's always, well, this is the best authority we have, but it's subject to being rationalised. This is the ratio of the case, but we can actually distinguish that case on future decisions. Also, avoid looking for intention or design. Don't say, well, what did the judges think when they decided this case? What was their intention? And so, sometimes people have very strong opinions of what the policy of the court was when they were doing something, particularly around something like the Mabo decision. And very occasionally you'll have a situation where a judge may speak later on when they're no longer a judge. They're at a dinner or something and they say, oh, when we were making that decision, we were deciding to do this. But usually you have no accurate source of what the judges think. And in some ways it almost doesn't matter to the system of precedent as to what the intentions are. What matters is what the principles are and how they interact with previous principles and how they interact in future cases. So it can be a bit of a hiding to nowhere to sit around and think, oh, what did the judges mean by this, when you're trying to decide what a principle means in a future case, because it is quite literally irrelevant to what you're doing. You need to look at the words and the rules themselves. But what you can do is start looking for patterns. And the human brain is wired for pattern recognition. It's what saved us from saber-toothed tigers appearing in the jungle, and we see a certain pattern and we go, that looks like a snake, that's dangerous, and that does, sets off all the cortisol alarms in our brain. And because the common law is a creation of the human brain, it has that same sort of pattern recognition, where sometimes when you look at the small scale, you can't actually see necessarily any trends, but you zoom back and you go, these are the same patterns appearing again and again. These sort of ideas are occurring and reoccurring throughout the common law. And again, that is where our the familiarity with the law becomes very important. And a lot of becoming a lawyer, you learn by doing. You can't learn by me saying this is what you need to do. That's what I'm doing right now. But you only learn by reading the law, by reading legislation, by reading cases. And I know that sounds like a teacher nagging, and we do a lot of nagging around that sort of thing. But it is the truth, is that the only way to understand how the mechanics of the common law works is to read a lot of cases. Read good ones and get some advice on one of the best ones to read out, because you don't want to read boring cases. But learn to read in that active way, where you're not trying to read it like you're reading a short story or a long story or a novel. You're not trying to read every word and put it all together. You're learning to skim, you're learning to locate the key areas. But what you're really doing is understanding how the language and logic works. And then, even though those cases may, one day be overruled, that's not, if that effort isn't wasted, because you can apply that reasoning and those ideas to any area of law, because you start to appreciate how that development works. And I can talk, as I have been talking, about my perceptions of that and how it all works and things to look out for, but there is literally nothing to replace that experience of actually reading and engaging with it. And that's the whole point, really, of studying at university. And it's easy to get distracted by I've got to get to the end, I've got to get my accreditation and get as quickly as possible and get out. But this is the opportunity that you have to actually think about the law and get that understanding in an environment where you've got colleagues and teachers and others who can help you and support you in this, and have those discussions. Because when you get out into the workplace, you're not going to have that environment where you can say, well, I was reading this case the other night and I thought this was really curious, because people just want to see your results. So the ability to actually experiment with this stuff, to read and engage in those discussions, is a very valuable part of your legal education. And that's something we'll be talking a little bit more about in the workshop this week.